My name is Todd Dieffenderfer. I'm Deputy Director of the City of Columbus Department of Neighborhoods, and thank you for joining us today. This year, our theme is Access to Racial Justice in Columbus. Really can't think of a better theme to have, and appreciate the Community Relations Commission for putting this together this year. Our first two sessions focused on community organizing and public health racism as a public health emergency. Those were really in-depth and engaging conversations, and if you haven't had the chance to view those, please go to our Facebook page where those recordings are available and you can see them. We will conclude our series in July with a session looking at resources from the courts here in Franklin County. Today we're going to discuss the resources that are available to help should you be subject to discrimination. Really appreciate all of the panel members who are joining us today. Pleased to be among them. It's a great opportunity to think about the resources that are available at the state and the local level to assist, as well as have a discussion about additional steps that could be taken at the state level to increase the protections for people across Ohio. Really want to really appreciate and thank Director of the Ohio Civil Rights Commission, Angela Phelps-White, for serving as our moderator today. The Civil Rights Commission is certainly a very important partner for us in this work. I also want to thank Community Relations Commission member Allison Poirier. She leads our Issues in Education Committee, and they're the ones who are responsible for putting this series together and the previous years and all the great sessions that we've had. Now I'd like to turn the microphone over to our moderator today. Director, the floor is yours.
Today, we will focus on new legislation that has been introduced or passed that expands or is intended to expand the areas in which discrimination is prohibited, providing additional protections at the state and city levels. So let's begin our discussion today talking about the additional protections that are provided at the state level. We will begin with the Crown Act. CROWN stands for Create a Respectful and Open World for Natural Hair. Variations of this act have been passed in several states. We are fortunate to have Representative Juanita Brent, Ohio representative from the District 12. First, Representative Brent, thank you so much for joining us. You introduced the CROWN Act in the Ohio legislature. Can you share with us what prompted you to introduce this bill, and what protections would be provided by this bill, as well as the status of this bill currently?
Thank you so much for the invite, for being here. I don't know if you can tell on my face. For one, I'm just so excited just to be here with this event. But what actually prompted me, and I don't know if anyone can see my hair at home, is that I have braids, and I've always been a place where I find a lot of value wearing protective hairstyles, no matter if I'm wearing cornrows like I am today, or micros, or even if I'm wearing my hair in its natural state, just completely out. And so being at a place that you know that I've received discrimination and I've seen this happen to other people at schools or different other places, I knew something like this was just very necessary. I was very inspired when I saw Senator Holly Mitchell, who actually introduced it originally in the California legislation too, and I saw it was passed, and I was like, well, if they can pass it in California, I said, there's hope for us in other states, because people should not feel that same type of pressure about wearing their hair in its natural states.
So you introduced the CROWN Act. Can you share with us what protections that act provide?
Yes, so what happened is that if someone received a discrimination with he was at a school, a public school from K through 12, or a public charter school, or you were at a place of work, or you were looking for a type of housing within anywhere within the state of Ohio, it will protect you. A person would have to file that with the state of Ohio within 6 months of the act, and it would have to be something that was written, put in writing, and you also have to put in an oath stating what happened. And that's very important, because when discrimination happens, sometimes there's a lag in time So this bill says it has to be reported within 6 months, which is very vital that we put that out there. And as this case was even introduced in this bill, which is House Bill 535, I've had people say that they were able to get a home because someone said they didn't like the way their hair looked. So we just have to get to the point where people do not feel like discrimination is okay.
Thank you. Where is this bill currently in the legislature?
So currently, right now, it was introduced in the 133rd General Assembly, and now Rep Hudson and I, who is my joint sponsor, we're about to reintroduce this bill again. It is just taking a lot of momentum because it's a lot of mess going on here at the State House, to say the least. But we are reintroducing this bill for the second time, and we're looking forward to having a little bit more movement than it did before. The last General Assembly, we only received one committee hearing. So for those who are just very concerned about people receiving discrimination at their homes, regarding housing, their jobs, and at schools, we're going to need everyone to come out and support and really say that this needs to pass within the state of Ohio.
Fantastic. Thank you so much, Representative Brent. Mary Turocy, as the Director of Public Affairs Civic Engagement with the Ohio Civil Rights Commission, the Crown Act has yet to pass, is going to be introduced in the state legislature. But until that time, and until it becomes actual law, is this negatively impacting the investigation of cases where hairstyles and textures would be the basis of a discriminatory act?
So on the state level, the Ohio Civil Rights Commission is responsible for enforcing the state's laws against discrimination. So we would handle cases that involve race-based discrimination or any of the other protected classes that you mentioned earlier. In a lot of respects, the Crown Act would help us in that enforcement because it would help provide kind of a statutory, a legal tool in our tool belt for enforcing cases that are specifically around hair or hair texture or hairstyle. But the commission still can enforce race-based discrimination. So there certainly are currently protections for race-based discrimination in some circumstances. So we really encourage anyone who believes they've been the victim of discrimination on the basis of race to come to the commission and file a charge, and we will absolutely do whatever we can to enforce it. But again, the Crown Act would help give us that kind of legal support for when those cases involve hair and hairstyle.
Thank you. Now, there have been other measures to expand or enhance protections against discrimination at the state level as well as at the federal level. House Bill 352 went into effect on April 15th, which expanded protection against employment discrimination. Mary, could you explain to us the changes that were made by House Bill 352, and how has the Ohio Civil Rights Commission approached these changes in discrimination cases involving employment?
Yeah, the biggest change for House Bill 352, and I should say the bill specifically really addresses employment discrimination. So we also have jurisdiction over housing and credit, disability in areas of higher education, and public accommodation. But in employment, now as of April 15th of this year, the commission has what's called administrative exhaustion, which essentially means that folks who want to file a charge of discrimination at the state level have to come to our administrative law agency before filing a lawsuit. So what it means is that the Civil Rights Commission kind of gets an opportunity to see the full landscape of those state discrimination suits, so we can collect data on all of them. The bill also expands the statute of limitations to 2 years for those employment claims. So instead of before, folks would only have 6 months after the harm took place, after an allegation of discrimination took place. Now they have 2 years after that harm took place to file with us. And then we would hold on to the case for at most a few months. And then if someone wanted to file a lawsuit, they absolutely could.
Thank you. Now, I mentioned that there have been changes also at the federal level, but it's also impacting us at the state level, not only in employment cases, but also in housing cases. And that's the definition of the term sex in Title VII was expanded by a U.S. Supreme Court case, Bostock versus Clayton County, Georgia, that was decided on June 20th, 2020. Can you explain the Bostock decision, how that expanded the definition of the term sex, and whether there's a bill in the legislature that would also include that expanded definition in Ohio law?
Yeah, so the Bostock finding essentially said that the Supreme Court, the U.S. Supreme Court said that the definition of sex included specifically in the federal employment discrimination law includes sexual orientation and gender identity. And the kind of common example that they gave for this is if I'm a woman and I marry a man and come to work and put my picture up and I'm congratulated for my wedding, but a man were to marry a man and be fired for putting his picture of his wedding up, then that's clearly a difference between the woman marrying the man and the man marrying the man, which is sex. So that sexual orientation and gender identity kind of falls under that category. So with the Bostock finding, because there's federal supremacy on discrimination laws, the state is able to enforce that definition as well. However, as you pointed out, our state legislature is working on a bill called the Ohio Fairness Act. Actually, it's two bills. There's one in the House, House Bill 208, and one in the Senate, Senate Bill 119. And those bills would put that definition of sex, that expanded definition of sex that includes sexual orientation and gender identity or expression, into Ohio statute. So essentially, it would really help the Civil Rights Commission by clarifying and making sure that these kind of like legal challenges that happen in the courts would be clarified for our purposes and our enforcement.
But it wouldn't be prohibitive of investigation should those allegations be the basis for the discriminatory act, would you say?
Yes, yeah, just because we don't have a state law does not mean that the Civil Rights Commission can't enforce those protected classes or the protected class of sex, including sexual orientation and gender identity. So we are taking cases at the state level of discrimination against individuals based on sexual orientation and gender identity, and we encourage folks to file with us.
Okay. And it should be noted before we move to our next level that the Bostock decision is also now being applied to housing cases as well. I know that HUD has put out a program to implement the new definition of sex to include that within their regulations as well. So we are also, the Ohio Civil Rights Commission is also investigating cases, not only employment cases, but housing cases that would have issues regarding sexual orientation and gender identity. So thank you so much. All righty, so now we see that the state is really working diligently to expand the protections with respect to discrimination. Well, Columbus has been equally as busy, so let's look at the additional protections provided at the city level. Much like the state, Columbus has enacted the Crown Act as well. The Crown Act has been enacted in several cities, including several cities within Ohio, Columbus being one of them. So let's talk to Elissa Wilson, who from the City Attorney's Office, who's going to explain to us the city's version of the Crown Act and how that act updated or enhanced the city's legislation prohibiting discrimination.
Thanks. So as Mary said, it's kind of another tool in our toolkit. The legislation makes clear that discrimination on the basis of race includes discrimination in the form of policies that specifically target hairstyles or hair textures that are traditionally associated with race. And so part of the legal background that I think provides a really good basis for understanding why this type of legislation is necessary is, as I think Mary already explained, there are anti-discrimination statutes that prohibit employment discrimination at the state level, at the federal level, and then of course, across many municipalities. And the way that those cases are litigated, there is a proof structure that's employed where typically the person who's claiming that they were discriminated against must initially proffer evidence, indicating that there was discrimination, but then the employer is allowed to proffer or articulate a legitimate non-discriminatory reason for the conduct. There unfortunately have been some cases in which courts have ruled that policies that target specific hairstyles are in fact legitimate and non-discriminatory. They are professional appearance policies. And so it was important to city stakeholders to very clearly articulate in our code that, that policies which target hairstyles associated with a particular race are discrimination on the basis of race unequivocally, so that in the event such a case comes up and say it is appealed up into the state court system, that there is no room for a court to construe that as a legitimate non-discriminatory policy because our code expressly says that it is discriminatory.
Lara Baker-Morrish, can you explain how the Crown Act is implemented in Columbus? Can you add to what was previously said in explaining that?
Thank you. Yes, I can. So in the city of Columbus, we have two different aspects of our city code that address discrimination in various forms. The one that Elissa was just referring to, where the Crown Act was added, was part of our general anti-discrimination code within our general city code. And so we have a large variety of prohibited discriminatory acts related to housing, related to employment, related to public accommodations that are framed within that particular part of our general code. Individuals who feel that they have been inappropriately discriminated against on basis of one of the impermissible bases for discrimination are able to file a complaint with the Department of Neighborhoods, who staff the Relations Commission, Citizen Relations Commission, that will then be looked into as to whether or not that has been inappropriately violated and against our code. And then an investigation will ensue. An attempt will be made to reconcile the act of discrimination. If it's unsuccessful, then at the tail end of that, there could possibly be a criminal prosecution. So when you're talking about accommodations, you're talking about employment, you're talking about housing on the basis of race, sex, gender orientation, I think also veteran status, national origin, ethnicity. Those are generally housed within that aspect of the code that will go that route. The second area of the Columbus City Code is the housing section. We also have provisions that are related to access to affordable housing. And specifically, we have anti-discriminatory provisions of our housing code that discuss source of income. And so that's in a separate place in our code, handled a little bit differently and related specifically to the ability to access affordable housing. And it prohibits discrimination on the basis of the source of the income that you are offering up as the ability to pay your rental payments. And so that would be enforced then through a mechanism involving our code enforcement aspect. And we're hoping to get landlords into compliance to assure that these discriminatory acts are no longer the case in the city of Columbus.
Columbus also has new protections for those who exercise their reproductive rights and receive gender-affirming medical care. Todd, could you, as the Deputy Director of Department of Neighborhoods, explain to us Columbus' approach to this new protection?
Sure, no, glad to. We were really thrilled with this collaborative effort that we just went through to update our code in Columbus. So Columbus has had civil rights protections on the book since 1991. Really, I think locally we'd say that we were leading the way, across the state of Ohio, at least at the municipal level on that front. And then seeing a number of other communities that have put things into place into their code to update. So it really, took an in-depth look at what we have here, partnering with city attorney's team to really walk through and look at that, working with the mayor, working with members of city council. So, you know, the Crown Act, Councilmember Tyson and Councilmember Favor, you know, really were champions of that, bringing that forward. Councilmember Favor really driving the source of income piece. And then Council President Pro Tem Brown was the one who was really leading the way, looking at this issue of reproductive rights and kind of the gender affirming care. So she engaged in a broad community engagement effort to really understand the issues that people are having, and then working within the framework of our city code to amend the definition of sex there to add these additional protections. So if an individual exercises a reproductive right, so it's hormone therapy, just, you know, you should probably read the definition officially, but, you know, just a variety of, you know, things that you would do there. If you are discriminated against because of that, that's now against the law here in Columbus. At the same time, also looking at this, if there's an individual who is undergoing care for again, hormone therapy or surgery for gender affirming purposes, that's also something that's now protected in Columbus. So we're glad to have that on the books here, and that end of June is when that officially takes effect here in the city.
Elissa, do you have anything to add to this new protection that the City of Columbus is offering?
Sure. I will say that, you know, I think that this really piggybacks on the Supreme Court decision we've discussed, Bostock. It's this notion that, you know, we really wanted to clarify that discrimination on the basis of sex includes not only discrimination on the basis of pregnancy, but discrimination on the basis of, you know, breastfeeding, pumping, and other reproductive and sexual health choices, which can include, as Todd mentioned, gender hormone therapy, perhaps gender affirming medical treatment of other types, as well as treatment, you know, regarding fertility, sterilization, reproductive capacity. And again, I think an important thing, I've gotten a lot of questions about, you know, these code changes. And one thing a distinction that I think is always important to keep in mind is that what we have in the city, this is an anti-discrimination code. So it is not a code that mandates that employers adopt any particular policies or procedures with respect to leave or fringe benefits or things regarding reproductive and sexual health choices. But what it does mandate is that employers that adopt those leave policies, break policies, et cetera, they have to apply them fairly and treat similarly situated employees the same. So they can't target for disparate treatment someone because, for instance, she is using her break time to pump. So that's an important, I think, concept that addresses a lot of the initial wave of questions that we've received.
It's important to note that what is occurring here is that as, for example, you mentioned the Bostock decision, that as these new cases are coming out, that the states and cities are endeavoring to keep up with the new definitions and those expanded protections that are coming out at the federal level to the state as well as to the city. So it's good to know that it starts somewhere and it trickles down for further expansion. So that's an important thing that we're doing. We're all keeping up with this evolution, which is very important. We've previously talked about discrimination in housing. There can be discrimination in housing, the workplace. I know the commission deals with credit as well as higher education as it relates to disability. But with respect to housing, Rhonda Gaines from the Columbus Urban League, can you please explain to us the work that the Columbus Urban League is doing with respect to discrimination in housing and the role it plays in housing investigations?
So along with the housing investigation, the most important part is education. because there's a great difference between discrimination and landlord-tenant issues that are going on. And with the moratorium going on right now for evictions, when clients come in, we want to make sure we explain to them exactly what is the difference between landlord-tenant and, again, fair housing. Once they come in and get the education, we are basically our Fair Housing Initiative program, which is a FIP, and we're partnered up with the Ohio Civil Rights Commission. So once they come in, we'll actually take the claim, take the information down for them, and file that information with the Ohio Civil Rights and along with HUD as well, so that they can go through and investigate that information. Now, once they're doing that, based on a number of individuals that come in and have complaints about different organizations or apartment complex or either mortgage companies, we have something called the affirmative fair housing marketing, where based on that, we go out and we hire like secret shoppers to go out and actually test those properties to see if other individuals are experiencing the same thing that this individual experienced. Now, once we take the claim, we follow the claim. Once it goes to the Ohio Civil Rights Commission and we file with HUD, we check up on the claim just to see what's going on with that. Anyone can file a claim based on whether they've been discriminated against on any of their protected classes. And we take that information and just try to reassure them. And we also work with the landlords as well to kind of mediate to see if there's something we can do to either get a mutual rescission, if it's something that's landlord-tenant related, on the cusp of it being discrimination. Our job is to basically protect the client and educate not only the client, but the landlord as well. I can't hear you.
What's interesting is you've just expressed how the state and the city work together on this cause. So whether a person contacts the state or contacts the city, their issues will be addressed because the two entities will work together to make sure that it's covered.
Correct.
Now that we've talked about the evolution of the new protections or expanded protections, let's go directly to what recourse does an individual have to seek racial justice? What avenues are there for them? What process do they need to engage in? And we heard a little bit of it from Todd Dieffenderfer. Let's start, Mary, with since we were talking about the collaboration between the Columbus Urban League and the Ohio Civil Rights Commission. First of all, note that the Ohio Civil Rights Commission partners with HUD to investigate cases, but we also partner with EEOC for the investigation of cases as well. So again, we have that collaboration between the federal government and the state, and then the collaboration between the state and the city. So there's a lot of resources out there for people to get their issues if they feel they've been discriminated against addressed. So Mary, can you please explain the investigative process or the recourses that a person would have if they felt that they have been discriminated against for any reason?
Sure, yeah. As we discussed earlier, the Civil Rights Commission can take charges based on state law, state anti-discrimination law, on the basis of employment, housing, credit, public accommodation, so being discriminated in a place that is open to anyone, and higher education specifically for disability. So if someone wanted to file a charge, they would be encouraged to reach out to first to visit our website, which is CRC, like Civil Rights Commission, also like Community Relations Commission, crc.ohio.gov. And that website has a link to file a charge right there on the front page, on the homepage of the website. You can click to get more information about filing a charge first, the kind of information that we require to file. And it also has information for our regional offices. We do have a Columbus regional office, since I know this audience is probably mostly Columbus based, but we also have regional offices in Cleveland, Akron, Toledo, and Dayton, and a satellite office in Cincinnati. Those offices are closed right now due to the pandemic. But if someone were to call and leave a message, an investigator could call back and you could talk through any questions you have and the allegations that you have to make sure that it meets our jurisdiction. Then that investigator could also get you started on filing a charge and provide any additional documents that you need if you can't file online. So once the charge is filed, we do require a signature, which is kind of awkward right now in the COVID era, but we require, you would have to sign the charge and get it back to us. And then there's, in the early stages of an investigation, there's an opportunity to engage in mediation, which is essentially an attempt at settling. It's a voluntary process, but it's actually very successful in the commission. We have about 82 to 85% of our cases that attempt mediation are successful. And we love that because it gets the charge done quickly. So if you're filing an unemployment basis, you can go back to work and kind of try to put it behind you. And the employer can hopefully improve their processes as part of that mediation. But it also just, by the kind of the nature of the beast of a settlement, is that everyone walks away from it feeling like they got something out of it. If the mediation fails, then it goes to an investigative process, and our investigators will ask for documents and do interviews and all the kinds of things that you would expect. And that investigation has to conclude by the end of a year. And that is actually a very short, it seems like a year seems like a long time to find out whether your charge of discrimination is found to be probable cause or no probable cause. But it's actually one of the quicker resolutions compared to like the federal and definitely to the courts. They can kind of drag on for a long, long time. And then after that, it's possible that the commission will take a case through our attorneys at the Ohio Attorney General's office, all the way up through the Ohio Supreme Court if necessary. So depending on whether we believe that discrimination took place or not.
Okay. You say it takes a year for the investigation. That is the statutory requirement.
Right.
The average amount of time, though, that it takes, would you say would be about 8 months to the case resolved?
Yeah, some cases can resolve very quickly. And of course, that would include mediation and settlement would, of course, resolve more quickly. Cases that go in full investigation typically take a little bit longer, but most resolve around 8 to 10 months. Yes.
Okay. OCRC also does training and education. I know Rhonda Gaines indicated that the Columbus Urban League engages in that as well. And that's a strong point, that education is very key. Does OCRC, what type of education and training does it provide?
Yeah, we provide training for both individuals who want to learn more, or employers or civic groups that want to learn more about their rights, and to employers that need to teach their employees about their responsibilities, especially large scale investigations. Large scale trainings to all of their employees. I know during the kind of Me Too era, we were providing a lot of sexual harassment and sex discrimination trainings because folks realized it had been a while since their staff had really been trained on what's appropriate behavior and what crosses the line into harassing behavior. But we also do that for housing. We're happy to talk to housing providers, especially small providers that maybe don't have that kind of infrastructure to have anti-discrimination training built in. We provide, as I said, kind of civic training for people who may own a business or work in a group and want to understand anti-disability discrimination and how not to violate the Americans with Disabilities Act, the ADA. So it really runs the gamut, and all of them are free. So you can reach out to our website, crc.ohio.gov, and there's some information there on how to contact us if you're interested in training.
Thank you. Todd, could you explain the city, any recourse that an individual would have in filing anything with the city of Columbus?
Sure, glad to do that. And Well, I wasn't here in 1991 when our code was first put together. It sounds like from what Mary outlined at the state level, people were reading one another's code here as we kind of put a process and a way of working together. So for the city, there's a couple ways to reach out to us. So it's columbus.gov/discrimination, or you can call 311 to start the process, or also give us a call at 645-1993. We do welcome folks to stop in, but just like the state, we're still following COVID protocols, at least for a little bit longer, so not quite open at this point. For a complaint to be accepted, it had to have happened, the issue had to have happened within the city of Columbus within the last 6 months. So Representative, we're following your lead there on the Crown Act for that one. It needs to be in one of the 3 areas of employment, housing, or public accommodation. And then also it needs to be connected to one of our protected classes. So race, sexual orientation, gender identity or expression, color, religion, ancestry, national origin, age, disability, familial status, or military status. And this is all on our website, so you can see all that information there. We do have an intake form, and on that form, you're asked to kind of outline the situation and maybe some things that were said, or putting down some information that shows why you believe treatment was different because of your membership in one of our protected classes. And then really to start the process, whether or not you are if you officially filed the form, or if you're just more kind of inquisitive and have an issue and trying to learn a little bit more, what we have you do first is talk with our investigator, and really through that conversation, trying to understand what happened and then what kind of a resolution is someone trying to get from that situation. And then as part of that conversation, it's providing some education there. As we're kind of seeing here, there's a web of services available to help. So informing folks of the Ohio Civil Rights Commission, informing folks of the Urban League, informing folks of their ability to go get a private attorney, to work with that. So just filling them in on kind of the full picture so they can decide what's the best next step for them. In our case, if somebody moves forward with us, just like the state, we really emphasize kind of formal, informal mediation. Ideally would like to have behavior change occur, or maybe a policy or something that happen to allow people to move forward. If mediation is not successful in our case here, as part of the code revision that we just had, there's kind of 2 options there. In one case, if it's something that's really a particularly egregious situation, it can be referred to the city prosecutor for evaluation and potential prosecution as a criminal matter. Or the opportunity there, again, if it goes through the investigative process, a recommendation can be made to the Community Relations Commission to levy a civil fine. So it's up to $1,000 for the first occurrence, or could go up to $5,000 if there's multiple occurrences within a 5-year period. But like I said, our emphasis really here is on mediation and trying to help, people work through that. Success that we've had in our process, physical changes being made at buildings to help with folks' mobility issues so that they can better get around their housing. We've had folks end up in having different housing options offered to them. And even in some cases, just being able to find out that an employee that somebody worked with at a store is no longer with that company. And, that's one of the ways that company has kind of addressed a challenge. So had a lot of success with that. But again, we just encourage folks, if you're having an issue, please go to columbus.gov/discrimination and learn more about what we have and reach out to us.
Rhonda, what recourse would someone have going to the Columbus Urban League?
So once we do the application, just like Todd was just saying, we actually send the information over. I forgot to give out the link. If you have issues with discrimination, you would want to call area code 740-580-FAIR, FAIR. Or you can go on, we have a dedicated website, which is www.ohio for housing discrimination. So they can go to our website. There's a video educational information on it. We always do educational lunch and learns like we're doing here right now for the public, for landlords, for tenants, for anyone, just to educate them on what's new, what's going on, because again, education is the key. And it's a big difference between landlord, tenant, and discrimination. I have to keep saying that and reiterating that, but just making sure we're educating, doing outreach, going to different organizations, getting with mortgage companies just to make sure everything is the way it should be. But as far as that goes, we're basically just making sure we're educating and getting all the information out there and making sure that, you know, just because something happened to someone else, it's not the same case as yours, just to kind of reiterate that and make sure that we give them the best education and mediation that we can. And try to make it like a one-stop shop. So if we can't help them, we know to send them over to Ohio Civil Rights, legal aid, just to make sure that we're making that when they leave here, they have a sense of comfort to know that we heard their concern. That's the first thing. They want someone to hear them and understand what they're going through and do something about it instead of pushing them over to the next individual. So I want to make sure that I educate, if I can't do everything needed here, I make sure I make phone calls and have them ready to go where they need to go next, because we're dealing with low to moderate income. So we want to make sure that when we're educating, we're not having them out driving different locations and they cannot be helped.
Education is very important, but I think the key thing here that I'm picking up on is mediation. I think that we can't underestimate the value of the ability to meet. A lot of times parties will file their charge and they're so emotionally involved that they just want to fight it. They just want to fight it. But mediation is not only an opportunity to vet your issues and your concerns, but it's an opportunity for a third party to hear them and to help both sides perhaps see how it could be resolved and get it worked out that way. Because I always believe, the one thing I always say is better to determine what you are willing to live with or live without through the mediation process than to have a court or someone tell you how that case is going to be resolved. Now, not every case is capable of being mediated to a positive resolution, but the conversation is definitely one that is important to have. And there is a teaching tool in that process as well. So I'm glad that you guys brought that up. The other thing that I wanted to bring up is, I know that we're in the age of technology, and so I hear a lot about websites and web addresses, but for those who are not as technologically bent, such as myself, thank you, Rhonda, for giving us a phone number. Is there a phone number that someone can call for the Civil Rights Commission?
Yes.
Mary?
Yes, there is. Sorry. It is the toll-free number is 1-888-278-7101. Again, that's 888-278-7101. There's also a local Columbus number, which is 614-466-2785.
Thank you. Todd, is there a number that someone can call the city?
Definitely. You have two ways to reach us. You can call 311, so 645-3111, or our office is directly, which is 614-645-1993.
Thank you. And I guess at this time, we're ready to take any questions that any of our viewers may have. Okay, so we don't have any questions currently. Representative Brent, you've heard a lot about the other protections that's offered, either that are already law by the state, but that's offered by the city of Columbus. Are there any other legislation, to your knowledge, that the legislature is currently working on to expand on some of the protections against discrimination that we may not have discussed or may not be aware that exist?
Thank you so much for that question. So the ones that have been introduced have been talked about mostly here today, and we are fighting tooth and nail just to make sure they get passed so we can complement all of the great work you are doing, everyone is doing here within Columbus as well as within the state of Ohio. So there's discrimination when it comes to hair textures, sexual identity, housing discrimination. And it's also a bill that was introduced about payment discrimination when you are trying to rent a home. So that discrimination too is being introduced. It has received now its second hearing within the State House.
Fantastic. With respect to source of income, Mary, I sort of skipped you because I know that we do not have any state law as it relates to source of income, but I know that this is something that's being discussed. Can you share with us what you know, where that would, first, what is the source of income? What does that seek to protect? And where are we in that discussion on a state level?
Yeah, I believe it's actually one of our local state representatives, Gerald's, who is has introduced source of income anti-discrimination bill, and I believe that might have been the one that Representative Brent was referring to that I think has had a couple of hearings in committee, and it would protect against specifically source of income, and maybe the folks from the city can talk about their municipal legislation, because while I know less about it, I feel like it is probably quite parallel, but it helps individuals who are being denied specifically rental opportunities because they receive things like Section 8 vouchers and other state benefits or federal benefits as their source of income to pay for their housing. So it recognizes that some housing providers are essentially eliminating those folks just purely on the basis of the receipt of those benefits, and would address that type of discrimination.
Todd, Lara, and Elissa, are there any other expansion laws that are being talked about at the city level that would expand protections with respect to discrimination? Either one of you can take that one.
So I would say that the city just enacted the ones that we've been talking about, source of income and the changes to the discrimination statute. So I think at this point in time, there's kind of a wait and see whether or not the changes that have been made have effectuated the change that they hope that they would make. I'm certain that there are members of council and the mayor's administration thinking about other aspects of discrimination and how that they could be best addressed in code. But particularly with source of income, even though it was passed in March, it has not yet gone into effect. It's not going into effect until July. So right now we're in that education period to make sure that the language that we've used has captured the behavior that we're concerned about. And yes, source of income is directed predominantly at vouchers and other sources of federal and state support, but it also is more encompassing than that even. It also addresses individuals who receive alimony or child support as part of their income, and whether or not those individuals are being discouraged from renting various housing that's available to them because the sources of their income are less traditional than your typical wages might be. So it's a little bit broader, and we're hopeful that it addresses some of the behaviors that we have unfortunately been seeing.
Does the city, I'm sorry, go ahead, Mary.
I was just going to say, I apologize. I don't want to take us off track, but I was incorrect about the sponsor of that bill. It's actually House Bill 182, and the sponsors are Representative Upchurch and Representative Miller. I apologize about that.
That's okay. So when you see these cases coming through, are you finding that a lot of these cases are, we were talking about mediation before, are you finding that a lot of these cases could be misunderstanding, or are you finding that these are actually true discriminatory acts that are being lodged against an individual for the reasons that we've spoken: color, race, national origin, religion, gender, disability, among others. Todd, would you say that a lot of times it's a situation where if the people come and talk about things, that they're able to resolve it, less so going to actual court action? Or
Definitely. I think in what we have found here, that kind of that informal or formal mediation really is very helpful. I think in some cases, individuals didn't have awareness of what the situation was, what somebody was experiencing. So just helping to inform and educate goes a long way in what we're seeing. To your earlier point about making, or what could be next for us at the city, the Community Relations Commission kind of reforming themselves a little bit with our new code change, and they're going to have a standing committee that really keeps an eye on what's going on, ongoing court cases or things in other communities, to think about what other sort of proposals to bring forward in the future. So definitely want to be mindful as to what else could be needed.
that sounds like something that is similar to the change with House Bill 352 for the Ohio Civil Rights Commission. The fact that all of the cases have to come through the commission before they can be filed in court. Mary, what advantages of that do you see having the Civil Rights Commission be the intermediary for, or the gateway for all of these types of charges?
Yeah, I mean, we discussed a lot about the benefits of mediation, and OCRC's mediation program is free. If you do file a court directly, I believe usually there's a cost to mediate, and so that I think is a really important benefit to coming to the Civil Rights Commission first, is it's kind of baked into the process. And that I mentioned that the most that someone would have to wait if they do want to file a charge in court is just a few months. That part of the reason why there was that delay of a few months before you couldn't go to court is to encourage folks to take advantage of that free mediation that we offer. But another huge benefit, which we're only really starting to really just now take advantage of or be able to see, is that prior to House Bill 352 and April 15th of this year, when a allegation of discrimination would go directly to a court action, it was kind of that allegation could kind of get lost in the mix of Ohio's 88 counties and their court systems. There was no tracking on a statewide systemic level of what discrimination allegations were coming in at the state level. The EEOC tracked, and the OCRC, of course, was tracking the cases we received, but the cases going to the courts were kind of lost. And now that we're receiving them first, they can still have that opportunity to go to the courts, but we get the opportunity before it leaves our system to track it, and so we can more accurately and more completely robustly see what the trends are and what is going on a statewide level.
Tracking is very important, as Todd brought up and as you just brought up. It does give you an opportunity to see what, if any, trends. I know for purposes of Ohio Civil Rights Commission, it gives us the opportunity to see where there are the repetitive problems. We get to track those cases where you always get charges filed against a particular employer. That's an employer that's always coming up in charges, or housing property owners and things of that nature. So you can see the trend, and the purpose of that trend is then not for us to necessarily go after and litigate, but it does give us an opportunity to see what their patterns and practices are, to help educate and help provide them the guidance they need to operate in a less discriminatory manner, or at least in a manner that would be deemed to be discriminatory at any rate. Okay, so as we start wrapping this up, I want to reach out to each one of you and ask each of you, what can an individual do to help either move legislation along that is being introduced or has been introduced, or where can an individual turn for help should individuals believe they have experienced discrimination? Now, I know we've talked about the recourse, but repetition is always very good to let people know where they they want to go, where they need to go, who they can call. So let's start out, Representative Brent. What would you like for the people to do to help further your mission with respect to the Crown Act or any other legislation that's within the state legislature?
Thank you so much for that question. And so when it particularly comes to the Crown Act, that has been assigned to the Civil Justice Committee. I need everyone who is hearing the sound of my voice to reach out to Representative Rep Hillier. His email, I'm gonna give you all of his business right now. His email is rep98@ohiohouse.gov. What it signals to him and his office is that people are really concerned. When we go and I talk to the chairman, the first thing people tell me is like, no one's concerned about this bill. People do not feel like this is the issue. Discrimination is not real. Racism is not real. And so when we go out and we reach out to that representative and we send emails to his office and we call his office, and I'm gonna give you his phone number too, is letting him know, like, no, like, we are putting you on notice. You need to take this seriously. Discrimination is a real thing. And as people who are not as fortunate as I am to be able to wear their cornrows to every day at work. So I just gave you his email, which is rep98@ohiohouse.gov. I'm also going to give you his phone number. Please call him and tell him I sent you. His phone number is 614-466-8035. Again, his phone number is 614-466-8035. This is the man that is holding our bill from not receiving where it needs to go at the State House. Tell him I sent you. Thank you.
Thank you for that. Mary, do you have anything to offer with respect to where individuals can turn if they feel they've been experiencing discrimination?
Absolutely. I mean, of course, I want to echo Representative Brent that it's so important for everyone to keep an eye on our legislation going through the legislature, and that's in support and in opposition. Use your conscience, pay attention to what bills are going through and what you think will be best for you and your life and your business. But when it comes to if you've experienced discrimination or if you know someone who's experienced discrimination, and you want to do something about it, we really urge you to reach out to the Ohio Civil Rights Commission. Again, we can answer questions, or you can just file a charge online and kind of take the process, take the bull by the horns and go ahead and file. So I'm going to give you again the website number, and as Angela pointed out, some folks don't have internet access easily available or prefer to use the phone. So I'll give you the phone number. So that is, the website again is crc.ohio.gov, and the phone number, the toll-free number is 888. I have to look because I don't have it memorized. I apologize. 888-278-7101.
Okay, Todd, what about the city? We're getting close to time here.
Sure. I guess I would just say, I don't think there's a wrong door. So whether or not, as you can see on this conversation, we're all connected together. So I would just encourage folks who are listening, spread the word that these resources are out in the community, whether or not you're going to us at City of Columbus, OCRC, the Urban League. If you're experiencing an issue, please reach out, and we'll help connect the dots to get you, where you need to go. But definitely, we're available at columbus.gov/discrimination or 645-1993 to start the process with us.
Thank you, panelists, for such an impactful discussion. And I want to thank the viewers for joining us today. Remember, your access to racial justice is just a phone call away.